create the HIPAA law and then say you have to let people violate it, even though they can't sue Mr. They can sue the clinic. And so the clinic can protect itself. It can obey the law. There is nothing that restricts the clinic from.
So it's not just a lobby, right? That accurately describe this building?
A public lobby, according to the law, is a public lobby. If it was not a public lobby, they would have to have a restriction started.
This is a different animal.
No, it's not.
Well,
it's not because
so
people
right there. Because if you don't see that this is a different animal and requires us to do our analysis based on the fact that HIPAA is part of it, then we don't have anything to talk about. A public healthcare facility where people come into this room that you can call the lobby because it serves as the lobby as well as the intake room, and because it's a small town and that's all we got.
Hello, Patriots. Well, I am back, finally, after having a video taken down by YouTube because of privacy complaints from a couple of public servants that work at the public health department out of Lincoln County. It's also the VA clinic it's my VA clinic where I go. Anyway, they've excluded me from there, from recording in a public lobby. So, what I've done so far is I appealed this decision, this exclusion, and so this video here is of the hearing that I had appealing that exclusion. This video is something, I think, it's an important video. It gives everybody insight of what is happening at our local levels in our government. Everything's turning authoritarian all across this nation. These public servants treated me with disdain. They seem like they're ignorant about civil rights. They don't care about the federal laws. They don't want to look at those federal laws unless it benefits them. I mean, you can see this all through this video. But anyway, enjoy the video. It's something else, really.
And
I'll tell you what I think I know to start, and you either party can correct me if I get it wrong, and then I'm going to turn to who was the person out of this group that was actually present for the event. We'll get you the facts of what the case is about from you, since you were there, and I'll get the county to give me their version to the extent that it might differ. Okay? So as I understand it, this is an event that happened on November 29 of 23. Was at or in the public health building on Nye Street. Was recording there inside the building, and he was given a notice of exclusion that date for 90 days with appropriate exceptions should he have need to get the services of the clinic, basically is what I think it's intended to be, those exceptions. So that's kind of the background, I think, of how we got here. So with that little bit of background, why don't you tell us what you want me to know about what actually occurred? Give me facts about what actually occurred.
Okay. I entered there, like you said, on November 29th into the public health department with this setup right here, my camera. And I proceeded to record everything that I could see from the public lobby there. And that is under the Constitution, under the First Amendment.
Don't give me the law, give me the facts
Okay.
at this point.
So that's what I was doing. And I was just recording everything, and they had some objections to that, and they came out and told me that I couldn't do it, and I told them I could. And I just continued to film, and they caused up a commotion, they did, with the other customers in there who were starting to ask me why I was doing it and that. So they created a commotion there, and all I was doing was recording, just standing there recording. And then they came up with this exclusion. I told them I wasn't going to accept that because it was in my rights to film there. And so then they said they called the police. So I said, well, I'm going to wait outside here on the sidewalk for them. So I stepped outside and I set my camera down. I just started recording the door. And then pretty soon 2 deputy sheriffs came up. One went inside and one stayed with me. Of course, I know these deputy sheriffs pretty well, actually. By the time, and we stood out there, and me and the one deputy sheriff just had some small talk back and forth with each other, and the other deputy came out with this exclusion and said that they were going to deliver this to me. So it didn't have any of my information. I refused to give any information on that. So anyway, at that point, all I could do was leave because it looked like I was going to be placed under arrest if I stayed. So I left, and then I looked at all the laws. I got everything together and researched it to make sure that I was right, which I am. And so then I made my appeal. And then now we're here. Now, Mr. Lip and I have had a conversation, a little bit of heated conversation on the emails.
Who's Mr. Lip?
Right here, Kenneth Lip.
Okay.
And in those emails, he also reiterated that if I went back over there with my camera, that they would call law enforcement on me. So it was like a threat of arrest for me to go in there and do my constitutional rights. So I just waited till this hearing because I wanted to get this hearing out so that I could show all the laws if anybody is not understanding of the laws and what the Ninth Circuit just did this last year in July. So that's all I have to say for right now.
Sure. Those are the facts as you understand, Mr. Gardner.
Your Honor, so, sorry, that's why I asked you how to address you, Your Honor. It's a habit.
Yeah, you can do that. I'm okay with that.
But
I
so,
only deserve that when I'm over at City Hall, but that's okay.
so I had a lady who had filled out the exclusion form, who is Ann Allard-Robinette. She's the division director for primary care for Lincoln County. And she filled that out, and because of some weather-related issues, she's still in Portland, but she did do a declaration. I had her draft up, so I want to provide not only that, but I also did a hearing memorandum. But with regards to the declaration, if I could approach, I've got a copy and an extra copy if you want to mark it up. But I'll go through that really quickly since I understand and may want all this read, but it basically says this is in relation to this appeal from the notice of exclusion of Michigan County Health and Human Services Clinic at 36 Southwest Nye Street. And one of my requests of Miss Allard-Robinette, since she wasn't going to be here, was not to get into any of the details that might be disputed as to what happened or who said what. But this is just from her position and her knowledge of that clinic. So it says that Miss Ann Allard-Robinette hereby declares under penalties of perjury that the following is true: that she is currently employed as the division director for primary care for Lincoln County, and in that role she's familiar with the clinic, the Lincoln County Health and Human Services Clinic, located at 36 Southwest Nye Street, Newport, Oregon, and the exclusion notice for November 29th. The clinic provides medical care, mental health treatment, and addiction treatment. The clinic is a HIPAA-covered health care provider. The clinic receives funding from multiple sources, including the federal government, the state government, grants, and local sources. This funding is tied to requirements and protections to encourage the use and access to public health resources for the benefit of the whole community. As a HIPAA-covered health care provider, the clinic is required to comply with state and federal laws, including the requirement to protect personal health information, PHI. The clinic has in place many policies to comply with these HIPAA requirements, including a restriction on filming within the clinic. Patients and clinic clients must come into the clinic waiting room in order to check in to the clinic for appointments and to obtain information. Patients and clients engage in conversations with staff, which include PHI, and fill out forms, which include PHI. The clinic also provides WIC, which is Women, Infant, and Children related services to clients. As a WIC services provider, the clinic is required to comply with state and federal privacy laws, regarding protecting the identity of WIC funding recipients. As a public health clinic and WIC services provider, the clinic provides mental health, addiction services, nutritional support to our entire community, and especially to our most vulnerable populations who may rely on public health clinics to meet their needs. Protecting our patients' and clients' PHI, identification information, and privacy is essential to ensuring access and providing these essential services to the benefit of everyone. Tyrants was issued the exclusion notice in order for the clinic to be able to comply with state and federal HIPAA requirements related to his filming inside the waiting room at the clinic. The clinic did not have written HIPAA-compliant releases of information from every patient present or scheduled to be present at the time. The policy at the clinic restricting filming at the clinic is applied to everyone equally, and it only has to do with complying with the laws in place related to protecting PHI and privacy and confidentiality regarding medical, mental health, addiction, and WIC services at the clinic. The clinic is not used for legislative, regulatory, or other government matters. The clinic's purpose is to serve and protect the public health. And that was signed yesterday by Ms. Allard-Robinette. I have no reason to contest anything that occurred that day, where it occurred. He was filming inside the clinic. I understand that he disagrees with laws that are in place, and he has a right to argue those. I will say that from the county's perspective, he is not clear on what laws actually exist with regards to First Amendment and the restrictions on time, manner, and place. And when the appropriate time comes, I'm happy to help explain those.
The county doesn't have any problem with your recitation of the facts. Do you have any problem with anything that Ms. Robinette said in her?
Oh, a whole bunch.
A whole bunch?
A whole bunch. Yeah, because she's wrong on just about everything on the law.
Well, let's start, take them by the number of her declaration that you disagree with.
Well, I disagree with 13, 14, all these, pretty much.
In that they talk
From
about.
13 on, I'm in disagreement with everything there.
If we could just look at the exclusion notice possibly, which Mr. Starnes says he doesn't disagree with.
Okay.
13 says, if we read the words in 13, Mr. Starnes was issued the exclusion notice in order for the clinic to be able to comply with state and federal HIPAA requirements. If you look at the exclusion notice, it specifically says that. I'm only saying that's what it was issued for.
Okay.
So is there something wrong with the
So
words?
is that all that's saying? It's not saying that this is true.
No, it
Is she
says-
saying that this is true? Because what's not true in that is unable to comply with state and federal HIPAA requirements related to the filming inside the waiting room at the clinic. There's no basis in law for that
Okay,
part.
so this again,
Okay, so I'm just looking at this.
both kind of dipped into what the law is here, and I really want to talk about the facts. So
All right, so
13 through
let me
17.
start over then. I'll agree with 13.
Mr. Starnes, 13 through 17 refer to requirements of the law that they're alleging apply, and that's the part of all of these that you disagree with. Am I correct?
Yeah, the law is, they're wrong on the law,
So
on all of
then
them.
18, I don't understand. 19 talks about what the policy of the clinic is, but again, they're referring.
Hospitals, military bases, the courthouse itself, anything that it's not always allowed to be filmed or anything everywhere in a public building. There's always been time, manner, and place restrictions. Even in a public park, there's time, manner, and place restrictions. The United States has ruled that the First Amendment doesn't guarantee access to property simply because it's owned or controlled by the government. Usually the distinction has been made also even where it is public, whether it's public forum or non-public forum. And so the level of scrutiny for First Amendment, deciding on First Amendment has to do with whether or not it's public forum or non-public forum, and then exactly where it's happening, and then the time, manner, and place. For example, being able to, the things you can say and do on the courthouse steps is entirely different what you can do inside the courthouse building, which is entirely different what you can do inside a courtroom. As you get closer to certain government activities, your First Amendment rights get narrowed. And and the courts have always recognized that that's the case, such as if somebody is being disruptive or somebody wants to record in the courtroom and the judge says, no, you can't record in here, and you still do it, you could be held in contempt, you could be locked up. Now that's completely different as your rights get bigger as you go to the courthouse steps or out at the street or anything like that. So that level of scrutiny changes depending on where you are and what you're doing. So the government actions are subject to a lower level of First Amendment scrutiny when the government function is not regulatory, licensing, legislative. So the differences in what somebody could do in this room, because this is the Board of Commissioners room, when we're having a hearing, people's First Amendment rights are completely different than when this room is being used for something else. When it's the same thing, what you could do here would be different than you could do in a public health or a medical facility, because that's not licensing, it's not regulatory, it's not legislative. It's a government operation, it's providing government policies, but it'd be the same as saying that because on the other side of that wall, that's still public government property. But it's not used for regulatory licensing or anything like that. It's used for office work and legal work. It's the use of it's different. It's not a public forum. It's what's called a non-public forum. So when a forum is considered non-public, the state can reserve that forum for its intended purposes, whether communicative or otherwise, as long as the regulation on speech is reasonable and not an effort to suppress expression merely because of the public officials if the public official opposes the speaker's view. That, I guess, is part of the confusion for number 18 of the Declaration of Ann Allard, because this is what the issue of First Amendment turns on, where she put in her declaration, the exclusion notice issued to Mr. Starnes had no basis in any message or view of Mr. Starnes. So it's not as though he was signaled out. It clearly says on his exclusion notice that he was excluded for filming in a HIPAA-controlled environment. So if anyone was, whether they are pro this issue or anti that issue, that policy from the county is applied completely equally. It has nothing to do with view. It only has to do with filming in that environment where people's access to public health and rights to privacy are controlled. So the clinic's waiting area is a non-public forum. So outside the clinic, no, I would say that more things can happen outside the clinic as long as they're not disruptive or keeping somebody from coming inside than what happens inside, where people are exchanging personal health information and even have their identities at issue inside the clinic. And so a policy that prohibits filming, photographing, and or audio recording in a non-public forum has to be reasonable and, again, not in an effort to suppress the speaker's activity due to a disagreement with his view. Any restriction on public access to non-public forums only has to be that reasonable and viewpoint neutral. In the present case, the clinic's policy regarding filming, which is that policy, which you were talking about with the standard, is, I believe, Exhibit 4 of that memorandum. And it has to do with filming based on the HIPAA issues. But their policy, filming in the waiting room, provides where the clinic provides medical treatment, mental health counseling, addiction counseling assistance, and access and providing benefits to the WIC program. It's reasonable, that policy is reasonable, and it doesn't have to do with whatever messages. It had nothing to do with that. The policy is applied without regard to any specific person, group, message, or view. The policy is only in place to protect personal health information and personal privacy as required by federal and state law And the clinic is not only entitled to employ that reasonable policy, but the clinic is also required to have that policy as discussed by, with regards to HIPAA and WIC. Trying to get out to the world, it would be applied to anybody exactly the same. In that way, it is reasonable, non-content based, and it is reasonable under time, manner, and place for where it's being enforced.
Okay. You have a different take on what you think the law requires here.
Yeah. Okay, this sounds like I work for the public health department over there, and I'm on trial here because I broke the HIPAA laws that I'm supposed to keep secure. But like we have said, I am not.
Interpreted that in that
Well,
way.
from listening, I mean, that's what it's on. This whole thing has been about HIPAA, and HIPAA has nothing to do with this. And I'll explain. First, they gave me this HIPAA and filming within the clinic. Now, this is a memo to the staff there. It's not to the general public. And that's because if you go into the law on that and you get into it, it says right down into this part, let's see, it talks about a covered entity, which are healthcare providers and other people that take care of personal information. Those are what are covered by HIPAA. That's what they're all about.
Right.
And then there's down further into this, it says the HIPAA privacy policy does not require healthcare providers to prevent members of the media from entering areas of their facility that are otherwise generally accessible to the public, which may include public waiting areas or areas where the public enters or exits the facility. And that's in this right here under Health and Human Services.
Okay, so let me see where that is so that I can read it for myself. Where is that?
I've got it right here.
Let me see it.
I don't have it highlighted.
All right.
That'll be, what page was it? Right here, on that third page. Yeah.
Okay, so I want to make sure, is this something that's in your memo too, Mr. Gardner, do you think, or is this something?
I haven't even heard what it is yet.
This is from, I think it was either Cornell or something that I got this. But this is just different things. We could probably pull up the law.
So we're looking at, what are we looking at?
I think this is memo from the
It's
Department
U.S.
of Health and Human
Health and
Services.
Human Services answering a question. The question being, can healthcare providers invite or arrange for members of the media, including film crews, to enter treatment areas of their facilities without prior written authorization? Answer, healthcare providers cannot invite or allow media personnel, including film crews, into treatment or other areas of their facilities. For patients, PHI will be accessible in written, electronic, audio, visual form, only in very limited circumstances set forth below. This HIPAA allow healthcare providers to disclose healthcare information to members of the media without prior authorization signed by the individual. If the HIPAA privacy rule permits or requires, as the individual authorizes in writing. Generally, the privacy rule does not permit healthcare providers to disclose PHI to media personnel, including film crews, without having previously obtained a HIPAA compliant authorization signed by the patient. So that's that release that I was so interested in from the beginning. It says you can't.
Well, if you keep on reading down there, that is them inviting media in. HIPAA laws are all about them, not me.
No.
They cannot invite somebody in.
So-
They have to get all the releases before doing that.
Healthcare providers cannot invite or allow media personnel etc.
But if you go down, it says they don't. But I've got other stuff here. That's just showing that they're not required to tell media just coming in not to be in there. See, that's what that is. But I have more that will go along with that.
Or the key word here is or allow. It says you cannot allow media personnel to do these, to go in there. And furthermore, that they must ensure that reasonable safeguards are in place to protect against impermissible disclosures, etc. So, I mean, the document that you just handed me says that the public health clinic, healthcare providers, cannot invite or allow media personnel.
And you go down further. Did you read that other paragraph that I showed you?
Yeah, what part of it are you looking at?
Wait a minute. Wait a second. This one.
So, this is this three-line sentence that you just pointed to, right?
Yes, I think so.
All right, so the HIPAA privacy rule does not require healthcare providers to prevent members of the media from entering areas of their facilities that are otherwise generally accessible to the public, which may include public waiting areas or areas where the public enters or exits the facility.
That's a correct statement of the law, Your Honor, when there are the releases in place, either attained by the clinic or provided by Mr. Stark.
That's a separate clause because it's going to go along with federal law here and other laws here that I'm going to show because I'm not done yet.
Okay. Okay, I've got your point here. Go ahead.
All right, now, this last July, the Ninth Circuit had a case which was 72F 4th 1043 Ninth Circuit 2023, Project Veritas versus Schmidt.
Yeah, I know that case.
Yes, in this one here, where it says Oregon previously required all parties of public in-person conversations to be specifically informed for individuals to record or disclose the contents of those communications. But now you can go in and do it surreptitiously. So I can take a hidden camera in there and record everything that I can see from public. Now, as far as public lobbies and stuff like that, it says even under the prior law, okay, that before it was reversed by the Ninth Circuit, said members of the public, including journalists, were permitted to use an unconcealed recording device to record statements in the following proceedings: public or semi-public hearings before governmental or quasi-governmental bodies, trials, press conferences, public speeches, rallies, and sporting events, regularly scheduled classes, similar educational activities, or public or private institutions. So that's what they could do before. Now you can do it in public lobbies, and just like under the federal laws, because the federal law also is applies to this building over here, since the VA clinic was added in there, which that is a federal entity. And concerning photographs or news for advertising commercial purposes, except where security regulations, rule orders, or directives apply, or a federal court order or rule prohibits it, persons entering in or on federal property may take photographs of space occupied by a tenant agency for non-commercial purposes only with the permission of occupying agency concerned, okay? Okay, but then it goes on, the see that the photographs for news advertising and general purposes are allowed in building entrances, lobbies, foyers, corridors, and auditoriums for news purposes. So those are the places that can be recorded in, and the free speech applies to this, and the free press applies to this. And the time, place, and manner that we're talking about is the time is open during business hours, the place is in the public lobby, and the method was recording, which Mr. Gardner already said that he agrees that recording is part of free speech. So that's under the Code of Federal Regulations. Then we have a couple of things that happened to me there. Okay, the first one is 18 U.S. Code 241, conspiracy against rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of having so exercised the same, or if two or more persons, that goes on, shall be fined under this title or imprisoned not more than 10 years or both, and if death results, it could be severe. So that's 18 U.S. Code 241 that was violated on me that day. And then we have,
Does that have to do with the exclusion notice?
yes, because my right to record as a journalist, as a member of a free press, according to the First Amendment, by them putting there that they're restricting me for videoing in there, that is a definite. And this was conspired to deprive me of that right here by her going to one of the attorneys in town. I don't know which one it is. I haven't been able to do any public records requests because they refuse to give names and everything like that, and so I've been held back from getting that information. Okay, so now 18 U.S.C. Section 242, deprivation of rights under the color of law, and that's what this is, under the color of law, this exclusion. Whoever under the color of law, statute, ordinance, regulation, or custom willfully subjects a person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be fined under this title or imprisoned, not more than 1 year or both. So those are the two things I've done. Now, 42 U.S. Code 1983 gives me the permission to do civil action for these things right here, which I am in the process of writing up the complaint now as we speak. I've got the letter of intent to sue ready. I'm going to find out here today who I served that to. But anyway, the other thing that happened there is these ladies over there got a hold of YouTube and had my video taken down, which that is a violation of my rights also, and my ability to do business, and they took down my news by doing a privacy complaint, which there is no expectation of privacy in public inside of a public lobby where they're working, and I have the right to record our public officials in the course of their duties so that we can make sure of transparency. And I was investigating some things there, and it looks to me like they're trying to hide that, and they had my video taken down. So these are all the things that are going on with me here, and I'm saying that I had every right under the Constitution, the First Amendment, and the Ninth Circuit reiterates that we have broad abilities to record our public officials and to record in public spaces. That lobby is open to the public. It is a public space, and the restrictions are, like Mr. Gardner said, going back through this door. If you see on there, it says authorized personnel only. I can't go back there because it says authorized personnel only, so I don't go back into those spots. So when I went in, there was nothing saying authorized personnel only. That was an open lobby to the public, and it is a public building. It is owned by the government, and it has federal and county offices in there. So I was within my rights completely and totally to record in there. And it's up to them on the HIPAA laws to make sure that I don't capture that. That's what these laws mean. It's up to, the onus is on them to keep that stuff secure. So they have blinds they can put down to cover up. They can take people in a back room if they have to do personal information when the camera's there. Things like this. When the press comes in, you cannot kick the press out because that means the government is becoming tyrannical, authoritarian, and they're not wanting to be transparent to the public. And that's what I have here.
Brief rebuttal?
Yes, I'd like to have a brief rebuttal. Again, I think it sounds like we agree on most things on this, that I guess there is a distinction between public and non-public forum, which is one of the defining issues for First Amendment. And the cases are very clear that there are public forums and non-public forums, waiting rooms being one of those non-public forums. In every case that's been determined, even ones that aren't medical facilities, have been considered to be non-public because they're not legislative, they're not licensing, it's not one of those situations that's part of the government in that way. It is part of the government's operations. And so when it's non-public, it is different. It has always been different. It is the same as, and there's plenty of completely public government buildings that you can put restrictions on. They don't have to be posted, not everything has to be posted, authorized personnel only. Well, he can't do this in a public restroom. It's completely public. There's no sign that says you can't be in here. He's not going to be allowed to film in there. There is some common decency and understanding of this, and there are requirements, as Mr. Starnes provided to the court, where, yes, everybody agrees, it sounds like, that this is a requirement put on the clinic. That's why the clinic abided by that responsibility. That's why they have the policy. He doesn't do it. He does. He posts this on YouTube. But he can't say that anybody who has access to YouTube in the world is going to be good with seeing somebody's personal health information, their payment information, anything like that that happens in, or their identity that happens in the waiting room. You can't get into the clinic. You can't get public health. You can't get mental health treatment. You can't get addiction services without going into the waiting room. And so I want anybody to get any of those because this is my right to be in here completely disregards the fact that the First Amendment can be limited based on time, manner, and place. Place matters. This is a place that provides these services. And this is a restriction that's not only put on by the federal government through HIPAA for medical, but based on the other restrictions as well for that facility. And the idea that understands what can be done with camera and zooming in and programs that can be used to edit or isolate images or audio or anything like that. And that is why these are in place, is because technology has gotten to the point where we can do all these things. It's not just a matter of somebody being in there and having cameras. I have this case that says I can do this surreptitiously and not let anybody know. You know, I don't know if there's a way to stop him from doing that. But you see, that's not on the clinic. The clinic has to restrict people from doing this when they know about it. When they can see it, it's intentional, unintentional, and they disclose it, anything like that. Now, if somebody is doing some kind of secret thing, has a little pin camera or something like that, the clinic can't be sued for that. They can't lose funding for that. They can't, if somebody wants to do that, now I'm not saying there might not be crimes involved if you did that, not with regards to just filming it, but if somebody used that to get somebody's credit cards, yeah, I'm sure that happens all the time in public forum, you know, in front of ATM machines, whatever. I'm sure you can do that stuff, but that is not on the clinic. The clinic, you can't reasonably think that everybody is trying to film and carry secret cameras everywhere. But when you set up a camera with a tripod in the waiting room where everyone can see it who wants to be in there, and people who don't want to be filmed have to turn around and leave. That's their only choice and can't get their services. You know, that is a concern. But when it's set up and it's in there, the county, the clinic, they are required to abide with federal law, which clearly says they can't have this happening in there. And so when they're doing that, it has nothing to do with Mr. Starnes. It has nothing to do with his view. It has nothing to do with his stance on anything or his wanting to hold the government accountable. It doesn't have to do with that message. It has to do with, it's a reasonable restriction on First Amendment in a non-public forum, and it's not content-based.
Okay, Mr. Starnes, you get a minute or two yourself.
Yeah. Okay, so I had read Title 18 U.S.C. Section 242, and under the summary on this thing, it talks about the things about this section. Section 242 of Title 18 makes it a crime for a person acting under the color of law, any law, to willfully deprive a person of a right or privilege protected by the Constitution of the United States. For the purposes of Section 242, acts under color of law include acts not only done by federal, state, or local officials within their lawful authority, but also acts done beyond the bounds of that official's lawful authority if the acts were done while the official is purporting to or pretending to act in the performance of his or her official duties. Persons acting under color of law within the meaning of the statute include police officers, prison guards, and other law enforcement officials, as well as judges, care providers, and public health facilities, and others who are acting under the public officials. It is not necessary that the crime be motivated by animus toward race, color, religion, sex, handicap, familial status, or national origin of the victim. So the thing is that this has been case after case all across the United States. The Ninth Circuit has done it twice. And I'm here to tell you that a public lobby is a public lobby, and policies and even state statutes do not trump the Constitution. The Constitution is the one that is the governing law in this situation here, because that is a public lobby. And the time was during business hours. The place was in the public lobby that I was recording. Public officials, which there are other cases that, and I don't have them in front of me, but several cases, and some are in the Ninth Circuit, that talk about being able to record public officials. And that doesn't just mean police officers. It means any public officials in the course of their duties. And as a member of the press, and you cannot take away the member of the press from anybody, because it's a First Amendment right for every single citizen of the United States can pick up a camera and go and find things that are being done wrong. So what I was doing over there was looking to see if they were violating the law. Now, if they were allow me to record something, somebody's personal information, that would be on them, but they can't kick me out to keep me from doing that, because that's against my constitutional rights. And so, and I've got some other avenues which I'm going to do, but it looks like I'm going to have to maybe sue this county, but I'm thinking that I can't believe that an attorney doesn't understand the rights under the Constitution as well as he should. Okay, so there's public forums and limited public forums. That is a limited public forum. So that means that when I go in there in that public lobby, if they have a door that says authorized personnel only, or you must be accompanied by somebody or something like that, then I cannot go through that. I'm limited. That's how I'm limited in that place. So I'm going to stand by the Constitution, the Ninth Circuit, and say that I had every right to be in there recording. I wasn't bothering anybody. They're the ones that came out and started getting loud and started trying to get me out and all I told them, and then everything's recorded. I got everything recorded on this thing. So, if anybody wants to dispute how it happened over there, I've got it all recorded. So
I'm a little bit familiar with the health clinic there.
Mm-hmm.
And so I want to tell you what I think the setup is there, because it's kind of a fact that I think is important here that we really haven't talked about. And so I'm going to give either one of you a chance to correct me or disagree with me on what exactly we're talking about. And I think what we're not talking about is a big city clinic where you walk in and there's an information desk, and maybe there's a medical equipment supply office, and there's chairs for people to sit in for dozens of people who are waiting for their patients to come out. This is a small town little clinic where once you walk in the front door, you're in the clinic. It might be used as the lobby with a few chairs, but it's also where all of the intake people are so that you go up to the window in this very same room to announce, I'm Jane Doe, I'm here to see mental health counselor Fred. Or, you know, I'm here for my UTI, if you're a woman, or I'm here to have my heart rate tested. So it's not just a lobby, right? That accurately describe this building?
You know, a public lobby, according to the law, is a public lobby. If it was not a public lobby, they would have to have a restriction sign up.
Tell me if I'm wrong in my description of what we're talking about here in this instance. I'm talking about the fact of what does it look like to go into this public health facility. Isn't that what it looks like?
Yeah, you walk into a public lobby inside the clinic with windows where from the lobby in the waiting room, right here, they can go up and say they have an appointment, and then they can be taken in the back. And but it is a public lobby.
Okay, well, you know, it's kind of unfortunate. It's one of those things where there's public lobbies and there's public lobbies.
Your Honor, the county doesn't disagree with your description of it, as well as it's addressed in number 8 in the declaration that the county provided about what takes place in there.
So the hearing memorandum goes to 6.
I'm sorry, number 8 in the declaration, the 2-page declaration from
Oh,
this.
from the
And
administrator of the clinic.
Yeah, which reads, patients and clients must come into the clinic waiting room to check into the clinic for appointments and to obtain information. Patients and clients engage in conversations with staff, which includes PHI, and fill out forms, which include PHI.
Okay, good. So that we actually have that in evidence, not just me imposing my view of it. It's actually that's the case.
Well, other places that I can go and record is in the DMV. I can go into the city council and record everybody doing their business there. I can go into the courtroom. It's the only place I can't record in the courtroom or in the courthouse is any place with a sign that says authorized personnel only, and I can't record into the courtrooms unless a judge gives it. Because the judge inside that courtroom, that's his place. He can't make a law for the entire building, but he can do it for his courtroom.
All of those wonderful examples that you just gave have nothing to do with protected health information. This is a different animal.
No, it's not.
Well,
It's not
okay,
because
so let's
we do this
I'm going to
all
stop you
over.
right there. Because if you don't see that this is a different animal and requires us to do our analysis based on the fact that HIPAA is part of it, then we don't have anything to talk about.
I'm looking forward to the lawsuit. I'm looking forward to the money I'm going to get from this county from the lawsuit.
I'll tell you what. I don't need to wait any longer here. This is a public healthcare facility where people come into this room that you can call the lobby because it serves as the lobby as well as the intake room. And because it's a small town and that's all we got. And people just have discussions with the intake clerk about why they're there for their personal health information. And the agency then that runs this show for the county has to do its best to protect the health care information of those people. So when somebody comes in and starts videoing all the people that are in this room there to do their intake for their health care issues, then it's not just a public lobby anymore. And if you continue to read down that media rules, number 3 that you pointed out to me before, it says you can't prevent healthcare providers to prevent members of the media from entering areas of their facilities that are otherwise generally accessible to the public. You still have to continue to read this where it says, and if PHI, if public health information might be accessible during filming or otherwise disclosed, the provider must enter into a HIPAA agreement with the film crew, and so then that sets up a whole other group of regulations. So this isn't, unfortunately, as simple as you would want it to be, and just rule out the fact that this agency has a duty to protect the healthcare information of all the people that come.
By violating someone's rights.
What's that?
By violating somebody's rights. I'm telling you, this is a violation of my rights on 2 different counts. The
Okay,
conspiracy is going to continue here.
So, Mr. Stein, you got your hearing,
Yep.
and I am going to put it in writing. I have to do that within 5 days, but I think it's pretty clear to you where I'm coming down from this thing.
Yeah, you're an authoritarian.
Nothing-
You're a tyrant.
Nothing could be further from.
No, you are a tyrant,
You
sir.
knew me, Mr. Stein.
I can't believe that you believe the way you do. You've been my attorney once before. I thought you were a good attorney, but you're not. So go ahead, give it to me because I got to go and start filing this lawsuit.
You're free to go anytime you like.
All right. The lawsuit will be coming, sir. Are you going to be defending them on that? I hope so.
I would hope so too, but I don't think I get to.
Oh, that's a bummer because I'd like to go up against you. I suggest you study up on this law a little bit better, Judge, because you're wrong on this.
Mr. Stearns, if you just go on to the next forum, I'm sure you'll get people that will have lots of information at their disposal, and will educate everybody from your side and the other.
No, we're going to go to federal court on this.
I didn't say that would be.
Well, and see, now that you're part of the conspiracy, I got to add you in on the lawsuit and this attorney right here. Thank you. Well, there you have it. They want to violate my rights some more, so now it's federal lawsuit. All right.